Oh, shoot. Hey, guys. So I have a intro video, but I accidentally didn't turn it on. Ah, I see. Can you hear me? I don't think you can see me yet. Hey, guys. How's it going tonight? All right. So I have this little video clip to get started. I'm going to go ahead and play it.
Who's going to say he was out driving around looking at the stars?
Your strategy is going to be, what if? What if it's this guy? What if it's a neighbor? What if it's that guy? So it's just more signs of desperation.
We came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can. Bryan's physical body is more stoic, how he sits in one place, and he will look at for a long time, and that means nothing. That's just how Bryan is.
So I just showed that clip. It kind of goes through the highlights of hang on, let me change this to, sorry guys. Yeah, so that little video clip kind of goes through the highlights of the hearing that took place last week, I think on Thursday. The defense had several motions that they put before the court trying to manage the way things are worded during the trial. It's really very interesting too. It's about an hour and 20 minutes, and I thought I don't know. It's a lot. I found it very interesting, but I have the whole thing that I could share with you. I just don't know that you guys will find it as interesting. But let's see. So this is Bryan Kohberger. He is the defendant. What I've got for you guys today is I'm basically going to go through the people who are going to be seen during this trial. And I think it's good to know the names of the people involved. That way you can look them up, find out their backgrounds and things like that. So this is Bryan Kohberger. This is his lead attorney, Ann Taylor. And the co-counsel, Eliza Masseth. And I didn't hear this woman speak, but she is, her name is Bika Barlow, and she's a forensic expert for the defense team. But I'm showing these people because we'll watch some of maybe the first like half hour even of the trial. Not the trial, the hearing, because the first part is especially interesting. This is the prosecutor for Latah County, William Thompson. I guess he goes by Bill, and he has a really nice beard. and once you watch some of the way he talks about things, he's really, I think he's a good prosecutor. This is Ashley Jennings. She's one of the deputy prosecutors, and Jeffrey Nye. So once we start watching the hearing, you'll see these people sitting at the table, at the different tables there. Joshua D. Hurwitz, he's a special prosecutor and a former U.S. attorney. And this guy seems really smart and very articulate also. This is the courthouse that this all started at. It got moved to Boise. This was the first judge. You'll probably hear the name a lot because it's interesting simply because Judge, his last name is Judge. And I mean, I don't know. I think if I was going to be a judge, I would want a different last name than that. But yeah, I just thought I'd talk about him a little bit just because he's got an interesting name. This is the judge that we'll be seeing today, Judge Steven Hippler. He's a real interesting guy. I haven't figured out whether or not I think he's like absolutely 100% fair or if he's not. They're supposed to be, and judges are people too. They have to do everything they can to be as fair as possible. But some of the things that was said, I'm kind of like, well, is he being fair? Does he already got an opinion in his mind also? But I don't know. I think overall, I think he's going to be a good judge for this case. Yeah, this is the courthouse that it's at now, Ada County, the Ada County courthouse. And the surviving roommates, they're also witnesses. Their names are Dylan Mortensen on the left over here, and Bethany, I don't know how to say that name, Funke or Funke. Anybody know? This was the police officer. The Idaho State Police officer is not pictured here, but this was the officer who did most of the work in Moscow. And this is the house. The address is 1122 King Road. Funky. Yeah, that's what I wanted to say, but I don't know. Names are hard to pronounce, especially for me. I seem to always say it wrong first, or maybe 5 times wrong. But yeah, so this is the house that has been torn down. They believe they've got all the evidence out of the house before it was destroyed, because this did actually happen a few years ago already. Yeah, I thought it was weird too. It almost felt rushed to me, like they tore it down, like maybe somebody was trying to hide evidence, but that's just the conspiracy theorist in me. I think typically stuff like that just happens. They made a good argument why it needed to be torn down, because it was, a big looky-loo place, and it just held this big stigma. People died, and it really affected that community. Not just the victims' families, but like the people all around that community. What we're gonna, this is kind of the stuff that I had planned to talk about. So there's a few things that's been happening. The defense is claiming there's like an overwhelming volume of stuff. And they've gotten dozens of terabytes of surveillance video, phone data, and interviews, and they don't have enough. They're saying they don't have enough time to look through it all. I mean, terabytes of that's insane amount of stuff. The prosecution is denying it's slow walking. Deputy Latah County prosecutor Ashley Jennings insists that everything requested was already turned over. I guess the thing is that they'd requested it and re-requested it a few times. And then when they finally got it, they got everything all at once, and they need more time to look through it. This is a discovery dispute, and they're common in large cases. The defense is using this to justify a motion to strike the death penalty. And that is something that they talk about in the hearing that they had last week. So there's several arguments that are being made. The Kohberger's team cites alleged discovery delays, as we just said. They also emphasize his diagnosis of autism, suggesting it should be considered a mitigating factor. The judge's reaction to these kinds of things, he appeared skeptical, and I think a few times he actually made the defense look kind of stupid. I don't know if I want to say that, but they kept saying, "Well, this is what's happening, judge. This is why we're doing it. We're still standing behind that." And the judge is like, "Well, you're not really reading it right," basically. So I think the judge is very smart. And I kind of agree that they weren't reading the information the same way he was. So if they do strike the death penalty, it's a major turning point in the murder trial. I mean, it's possible that you can live for 40 years on the death penalty on death row or whatever. But hey, Crafted, thanks for joining us. Yeah, we're just kind of going over the hearings that happened last week in the Kohberger case. So there's also a lot of things that they're trying to take out of the evidence. There's the 911 audio. The defense wants the chaotic noon hour 911 call. Judge, they want it kept out and edited. So Judge Hippler signaled that he would likely allow it with some redactions. And, I think there's other evidence too that they're talking about taking out and redacting parts of it. The defense argued that the prosecutors are trying to use a earlier traffic stop as some sort of way to show the defendant in the car, giving the same phone number and all of these things to make him look guilty. There's like a whole like half-hour discussion about that during this motion. And it's really interesting. And this is one of those times where the judge kind of made the defense team look kind of unintelligent, or they misunderstood the laws and what they were describing, or maybe they got the right idea but they're just using the wrong verbiage and the wrong what is it called, statutes. They're trying to remove the Amazon shopping history and the bushy eyebrows description. They want to take some of the more brutal and horrific images out of evidence. There's a college essay that he wrote that shows how he knows how to, clean up a crime scene. There is DNA under the victim's fingernails, and prosecutors claim that they do not believe any of the inconclusive DNA found under, excuse me, at least one of the victims belongs to Kohberger. Positing that he wore clothing to prevent shedding of forensic evidence. See, that's a huge one. Evidence rulings shape the entire trial narrative. You got to realize that when the jury's sitting in that room, they've got one job. They have to look at specifically what evidence is presented to them and make a decision based off of that. So all this stuff that they take out of evidence, or they redact from evidence, or put into evidence, is all those things that the jury has to make a decision on. And it can 100% change the entire outcome of a trial if they take some of these things out. And so you can imagine the defense wants a lot of stuff removed. Yeah, so I don't know how many more slides are left, but I'm going to play some of this of the hearing. I think you guys will.
And use of the term psychopath.
Like here,
Today we.
So before I start, they are about to describe some things that they want the verbiage taken out of, witness testimonies and things like that. They don't want these words implied, and because they think that it will unjustly cause some bias towards the defendant. But I'll just let you guys listen. I think we'll probably listen for probably 5 or 10 minutes, and then we'll pause.
We have a number of motions to get through. What we don't get through today, we will take up tomorrow. You should have received by email a listing of score sheet of the motions and a rough order that will take those up in, separated into groups. Within the groups, we may not stick exactly to order, and we may take up several within a group if they're related at the same time. And so with that, let's take up defendants' motions in limine regarding inflammatory evidence, use of the term murder, and use of the term psychopath or sociopath.
Thank you, Your Honor. I'm guessing from the court's comments, the court wants me to address all three of those. I'll do that then. Your Honor, the motions are brought to the court based on Mr. Kohberger's constitutional rights and the rules of evidence and relevant case law. With regard to the inflammatory evidence, that is requesting that the court issue an order preventing the state from trying its case with an emotional appeal or an excessive use of emotional phrasing or an excessive use of repetitive photographs. Certainly, we understand that there will be photographs that we may not like that come in, testimony that we may not like that will come in, but what we're talking about is an excessive use of emotional appeal. That the examples that we've seen in relevant case law come from State versus Ellington. In that case, the prosecutor repeatedly used a phrase that was inflammatory about the defendant having run over the wife of a witness who was testifying. And that was found to be inflammatory because of the excessive use of that phrase. Additionally, in that case, there was an appeal to juror emotion when the state sought testimony from a witness about why he might have left his job. Those are examples of what we're talking about. The court has to do the rules of evidence balancing test, and to do that after the state has elicited inflammatory testimony is difficult to undo and puts Mr. Kohberger in a position where the jury's already been inflamed, and so we're seeking to prevent that. Your Honor, I will move then to our motion regarding the murder term. This motion is also based in Mr. Kohberger's constitutional rights to due process and to a fair trial. This is not a motion to ask the state not to use the term murder. That's going to come out when the court reads to the jury the charging document. That's going to come out in jury instructions. This motion is about the state, through its witnesses, labeling Mr. Kohberger. That invades the province of the jury. Mr. Kohberger sits here today. He's innocent, and it's up to the state to bring evidence and a jury to decide if that's different. The state, by using that kind of term as applied to Mr. Kohberger, gets in the way of what the jury needs to decide. Back when we were looking at a change of venue in this case, we worked with a social scientist named Dr. Amani El Aleli, and she talked a lot about how bias is made in people and how we think about things and how we remember things. And one of the things she talked about, and her report is in the court record, one of the things she talked about is the influence of people in a position of authority. And for the state to come in and label Mr. Kohberger in their position of authority or ask a witness, especially a witness in uniform, to do so is very detrimental. It's inflammatory to Mr. Kohberger, and it would...
Outside of opening statements, perhaps, where the state might say, we intend to prove the defendant murdered the victims, perhaps in reference in voir dire, that, you know, in this case, the defendant is accused of murder. I'm having a trouble understanding how this would come up during the evidence phase of things.
Your Honor, that's why I'm asking the court to issue an order to prevent it from coming up.
Sounds like you're asking me to issue an order that says the state shall not commit prosecutorial misconduct, or the parties will follow the rules of evidence.
Your Honor, I would like an order that the parties will follow the rules of evidence.
I'm sure the state would like one too.
I'm not going to oppose that, Your Honor. We'll get to the state's motion.
I don't think I need an order because, as the name implies, they are rules, which means they will be followed.
Your Honor, in an abundance of caution, we bring these motions, and that's based on review of case law and based on years of experience when things happen in trial. I found and I believe that it's relevant to bring these kinds of motions before the court now and have all of the parties aware of.
I think there's maybe a difference between bringing them to make sure that the issues are highlighted and the parties are vigilant versus perhaps entering sort of prescriptive orders that are so broad and vague in nature that they are essentially meaningless.
Your Honor, this is my opportunity and the place that is reserved for the defense to bring these motions. I think that they're important motions, and with court's orders, it makes it more clear. Even if the court order isn't spelling out, you can't say this, you can't do that. I think there's an awareness, and I think it's relevant to have that order. I think it's important to have that order. And most of all, I think it's protective of Mr. Kohberger's constitutional rights to have that order. That's our request with regard to...
Address sociopath or psychopath? That
Yes,
seemed
I'd like
the
to
state
address...
was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not to use those terms, I don't need to make a full argument on that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again under Mr. Kohberger's constitutional rights to a fair trial and due process of law. This motion is really spelled out in Dr. John Eden's affidavit when he talks about the unreliability of tests that might label somebody in that particular way and the danger of having that label applied to somebody. If that's allowed to happen, then Mr. Kohberger is colored with an opinion or a way the jury will view him that is unfair. And our request is that the court not allow the state to label him in testimony as a psychopath or a sociopath. Because any kind of testing is unreliable, that would relate to, or that would become problematic within the rules of evidence to do so, and the inflammatory nature of those kinds of labels would...
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This, again, is my opportunity to bring a preventative motion to protect Mr. Kohberger's constitutional rights. And that's the purpose of that motion. Thank you.
Thompson?
Thank you, Your Honor. And as the court is aware from the responses that we filed, Mr. Nye and I actually kind of divided these motions up. We didn't realize they would be heard together. But as to the inflammatory evidence, what the court has noted is exactly what our concerns are. In the defendant's filings, he doesn't specify what inflammatory evidence he's concerned about. He doesn't define the phrase exceptionally inflammatory, nor are we aware of any definition of that. The words just seem to be used loosely and freely here. And in fact, in the defendant's reply, he acknowledges at page 2 that he really doesn't even know what he's trying to object to. He's asking the court to presume that something's going to happen or anticipate something without a basis for it. We don't see any basis for the court to enter an order. We intend to conduct our trial professionally, and we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms where they're equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder. So I don't, obviously the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. Certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential gristle, meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene. I would imagine from what I've seen, some of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel it's really does anything it doesn't advance the ball for me to abstractly say don't use inflammatory evidence. So I'm not going to do that. I will rely upon the obligations of counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding
I'm gonna
the
pause it right here. This next part is really interesting. You're going to hear this. I guess it's a statute 404B that they're going to be talking about, or 404C. I can't remember. We'll listen to it for sure. But I just kind of wanted to, just kind of take a moment to digest what we just saw happening. Why is it important not to use the term sociopath and psychopath and murder and things like that? You got to remember that the people that are going to be making this decision are regular people, and people are persuaded by different things. And those words have a high emotional impact. So if you're saying things, first, also, you got to remember that they're not allowed to be making their argument throughout. They have to be showing the evidence and going over the evidence in a logical way so that the jury can make a decision. That's why you hear, I object, argumentative. You're supposed to save that argument until the end. The trial is going to be mostly just presenting evidence, talking to expert witnesses. There shouldn't be any argument. There shouldn't be any opinions put into the testimony. But if you phrase things a certain way, it's going to trigger, some emotional stuff for the jury, and it could, be persuasive. I don't know. I've got jury duty next month. I've never had jury duty. I don't know if first of all, they got to pick you. Like, you go in for jury duty, you don't always get selected for a jury. But I don't know if they would pick me. And if they did pick me, I think it would be a very difficult thing to do, even if it's just a misdemeanor. It doesn't necessarily make it any easier to be on a jury. But the jury is supposed to look at the evidence and make an objective decision based off of that, the facts. But the language used can kind of, I don't want to say manipulate, but it's persuasive. Everything we see, everywhere we go, like, everything is like presented kind of in a persuasive way. It's just kind of human nature, I think. That's why we have advertisements. They're like, look at our stuff. It's better because of, and they're persuading you, and you're talking to somebody about getting a job and you hear them persuading you why they're great. So I think it is important to navigate this the way the defense did. I don't think the judge really thought that it was necessary because of the rules that are already in place on how evidence is presented. But it's good to talk about it, because right now they're basically setting up the rules for this hearing. Anything outside of the scope of what is already a rule, they're just talking about these things. And obviously the prosecutor said he wasn't going to do that, but you don't know for sure. They all have their plans. They have their, the prosecutors have all the evidence. They've looked at it all, and they have made, they basically have a plan on how to present that evidence to win the jury's decision. That's their job. The defense is basically trying to block all of that and present a shadow of a doubt so the jury can't make the decision. But this next part, I'm going to go ahead and start playing it here. I'm going to look up that 404C and see if I can find it find the actual statute and read it a little bit later, but it is interesting. The judge talks about it. And he also talks about 403, which he says might be closer to what they're talking about. But it's really interesting the way it's discussed, because it is important to discuss it, but the judge doesn't seem to think this defense team is talking about it the right way, and it's very clear. So I'll go ahead and get started. Let this play for you guys.
If 404B evidence that was noticed in this case, which is the traffic stop.
And I'm prepared to address that, Your Honor. I do note on the court's list that the state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court prefers.
Let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Good. Ms. James was going to handle that. We're happy to just submit it to the court.
I think it's
on
the
the
defendant's
files.
motion, so if they want to argue it, they can.
Your Honor, it's the state's motion.
Oh, is it the state's
It is the
motion?
state's motion.
I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. If you want to, Ms. Jennings, address that briefly, you may.
Thank you, Your Honor. I will.
And this relates to the concerns that the defense may say something like the state's trying to kill Mr. Kohberger or something of that nature, as I understand.
Yes, Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments, that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And defendant replied basically saying the same in their response, that they suggest he use phrases that comport with existing language and statute and jury instructions, and that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
Right. So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of a better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right, let's take up 404.
Good morning, Your Honor.
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan. And so the state has expressed that they plan to use
how you
that
can
paper.
use it. It's.
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of colloquial term is a prior bad act to show that the party acted in conformity with that they have propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in-run. The same example that I will give you has to do with the Amazon records.
I don't think that we're reading the rule the same is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is, in essence, trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
But it's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
But that is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in-run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice, they should not be able to argue evidence is a prior bad act or make any attempt at an in-run on that rule.
So I'm not understanding what you mean by an in-run on that rule in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th,
right,
2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I think I understand what you're saying. I just think we're
So I think
completely missing
Okay.
each other's understanding of the rules of evidence.
Well, I still stand by my position that the state should not be able to in-run that, and I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or keep
On
it
the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our...
Oops. Sorry guys, I don't know what just happened. Is it still playing for you? My computer screen just glitched. I don't know what just happened, but I'm gonna try to add it back. And okay, let me see if I can. Okay, just give me a second. I don't know what happened. My screen just went blank and then the video disappeared. Does anybody remember about where we were time frame wise?
We have a number of motions to get through. What we don't get through today, we will take up tomorrow. You should have received by email a listing of score sheet of the motions and a rough order that will take those up in, separated into groups. Within the
Guys,
groups
if
we
you can
may.
hear me. Okay. Can you guys hear me? Are we still live? I have no idea just what happened. It just like the screen went blank for a second and then I couldn't click on anything. But I think you should be able to hear me now, right? Okay. So let me try to get the video back. That's never happened to me before since I started using StreamYard. But I'm not sure exactly where we were when this.
We have a number of.
Let me see if I can guess. So we're somewhere around here, I think.
In as a bad act. One of the ways that we contemplated draft.
But yeah, I guess before we start, I'll talk about this bad act that they keep mentioning. I was trying to type it whenever this glitched, but the bad act thing is some sort of phrasing that they use to prevent evidence from going forward with in the trial, because it shows like a history of crimes of some sort. They're talking about a traffic stop. I believe they're talking about Amazon order history and things like that. And they keep saying that's not a bad act. The traffic stop by itself is not a bad act either. It's essentially, I think they argue that the prosecutors want to present that so that they can show him in the car giving his phone number to the police, and that they want to use this 404 as a way to prevent that from being shown to the jury. But I'm going to go ahead and get this started going again. Hopefully we're close to where we left off.
Drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But in because we didn't know what they would raise, we raised it in this form, which is without notice. They should not be able to argue evidence is a prior bad act or make any attempt at an in run on that rule.
So I'm not understanding what you mean by an in run on that rule in this context.
By saying that the argument about the Amazon purchase is that was prior to November 13th,
Correct.
2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I mean, I think I understand what you're saying. I just think we're
So I think,
completely missing
Okay.
each other's understanding of the rules of evidence.
well, I still stand by my position that the state should not be able to in run that. And I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or
On
keep it
the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car that is not just the make and model. It is Mr. Kohberger's statement that he doesn't think seat belts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop.
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So it's
What year?
of 2022. So it's remote.
Before the murders.
Yeah, yes, before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, and so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, well, I can't remember the name, the maker.
Hyundai
Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state has, the state is.
Sounds like that makes the evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, and you make this determination of what the automobile is, et cetera, to me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but.
Okay, well, they've noticed it as 404B evidence, so I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
You don't get
his
to,
phone
and I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
I think after what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern within the video, as I understand it? First, you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another of violating the traffic laws in some way, including by not wearing a seatbelt. And so can you address that part of it, the prior bad act, and how the court should deal with that? And then also I am concerned with the issue raised about the communication between the officer and Mr. Kohberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. And I think when you review the video, you can the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. That's a preposterous concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. That's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thank you, Judge.
Response?
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, the make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case, and so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
All right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSalles paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote-unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so I don't think we can say that the shot clock has run out on that at this point, but certainly as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, the prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. So as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically a prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile, and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404 or notwithstanding 404B and 403, I do want the video potentially, I'll look at it and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer that was mentioned that, that Mr. Kohberger questioned why the police needed his phone number. that the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant, and it does potentially create some some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that he, his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
So, guys, this does go on for another, I think, half an hour or so. This first part, I think, is the most interesting part. If you're not the type of person who knows much about how trials work and things like that, I think this case, because everything is being streamed, or it seems to be, it's a good one to actually get involved with. And I think, that's why I went through like who the people are, so you can kind of, keep an eye on this, and it'll make more sense the more stuff we see happen. But I don't know what I think about the defense team. Their argument obviously wasn't great, but it was important to bring it up. I just don't know that it was effective in the way that they had hoped, but maybe it is. I mean, it could have also backfired and gave the prosecutors ideas that they didn't already have. But I think the general idea is that they want to show Kohberger clearly in the car, giving the phone number, and I'm going to try to follow this case, Cuffew. I do as best I can. I work during the day, so I can't, watch this when it actually is on there. And I didn't actually get to watch this until yesterday, actually. And I watched it again this morning. And it's just really incredibly interesting. There's a lot of stuff that we see are happening here. They're making valid, I guess they're valid arguments, but they, you can see how the judge, weighs these things, because their defense is making motions to, keep things out so that the jury does not hear them. That is their best way to, win this case. And then at the same time, the prosecutors want to do the opposite of that. They got to show, without a doubt, they have a high burden. They have to prove without a shadow of a doubt that he's guilty. And that's what they're going to try to do. And if, their key evidence is being removed, they can't do it as easily. It's hard to say what evidence is actually there and that they have, that they know already. And then, closer to trial, more and more stuff is going to be entered into evidence, and other stuff isn't going to be entered in. So it's really not looking good for the defense, just in this light. You can't really determine what a jury is going to think or feel. When they start picking the jury, each side is going to, try to pick jurors best for themselves, and each side gets to remove a jury member for, no reason at all, or they'll make arguments that they don't think that jury member is going to be a good fit because of XYZ. But I think they actually get to, take one or two off completely, each side, I think, but I'm not sure exactly how that works. But yeah, this judge, when I first saw this and I listened to him and I saw him sitting there with his like this, I was like, oh, wow, this guy's like bored, but he's actually intently listening. And, he's trying to hear what the defense is asking and trying to see how it relates to that rule that they're talking about. He is trying to like be fair about it. He does make them look kind of, misinformed or something, but I don't think he's trying to offer that maybe there's other ways to argue that, I think is what he's saying underneath everything else that he does say. But when we see Bill walk up there, he totally is like comfortable. He isn't like disturbed about anything that was said. And he just looks really cool too, but I don't know when the next date for any type of hearing is. I can probably look it up. But I would recommend, I'll put the link to this video. There's several places that have the whole entire video that you can listen to. I believe this was streamed from the court, so it's actually on their state website somewhere, but I found it on somewhere else. I can't remember where. There's also a lot of news outlets that have like cut out pieces of it. And I think those are good to watch to give you the general idea of what's happening. But if you don't watch the entire thing, you can't see all the nuance that's going on here. And it's really cool to see it, I think. So do you guys want to listen to a little more? Or do you want to call it a night? I know it's late for a lot of you. It's only 8:15 here, but I can watch probably 10 or 15 minutes more if you guys are interested. Or maybe we can watch some more later. Yeah. Okay. I'll go ahead and play it for a little bit. Here. Yeah, if you guys want to go, I mean, that's fine. I get it.
All right, let's talk about who is going to be in the courtroom.
Yeah, I thought they were going to be a little bit longer, but yeah, I get it. It's late. I actually intended to do this yesterday, but I didn't get around to it. And then I was going to do it earlier this afternoon, but I was up all night writing, and so I ended up like with a headache, and I slept half the day. So it ended up becoming pretty late, but I can link it. And you can either rewatch this. I think I'm only going to like stick around for another 15 or 20 minutes and just let this play. But I'll find a link that I can give you guys. I'll leave it in the descriptions, and you can find the entire video if you want to watch it yourself.
Amongst the victims and the defendant's family in general, in terms of a reserved seat. I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-06-1B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of the defendant's family, but that's, I think, the defendant's motion, so I'll let them address that first.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years. And by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, "Without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged." The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held, the assistant district attorney's blatant abuse of the trial court subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, who it would be even rational probably for the state to actually call. At best, there's one potential family member that they may see a reason to call. The state knows that Bryan's family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber, and for our client, the jury will know that he has people there to support him. Mr. Kohberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment, has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support Mr. Kohberger.
The reason you can't simply take up whatever family members you may need to testify in your case in chief right at the beginning. Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them and picking them up again. And so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendant's support family here in the courtroom.
I do too. And I guess my preference would be for that, even though it would be out of context and interfere with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
Constitutional right is not absolute and it bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says that court can't use the exclusionary rule where in good faith a person who was otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you. I'm going to take this matter under advisement. The defense raised some cases. I want to read those, though I don't think they were precedent on this court setting. I have reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think about to use counsel's word, the humanity. I think that, I can only imagine the family of Mr. Kohberger is devastated by these things. That's nothing that they did. And I think their ability to be here to see the trial is important. And to the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on a alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course. All right, let's talk about the defendant's motion regarding conditions as an aggravator, and this is the concern about using the defendant's alleged autism disorder diagnosis as a aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for trifurcation with the death penalty, and that was denied. But we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Bryan, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Bryan's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Bryan is. We seek to prevent the state from using those kind of characteristics against Bryan. We seek that in the way of testimony they might bring. Sometimes Bryan will talk longer than maybe other people want to listen, and that doesn't mean anything.
Well, I assume he's not going to be talking in court unless he's testifying, so.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating evidence against Mr. Kohberger, and that's what we don't want. We want to be able to present, if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has and to prevent the state.
Reading the the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do with, how we deal with that with the jury in terms of the penalty phase, right? If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
How would they use it as aggravating apart from arguing to the jury that, well, because he has this condition, it means that he is, I'm just making this up, obviously, is inclined to not follow the norms of society and presents a greater danger or something like that?
Your Honor, the order would prevent the state from, on the front end, in presenting their aggravation case, from using the conditions, the way autism works for Bryan against him, to say that he does things that are consistent with autism and that that's an aggravating circumstance. I'm
just having a hard time envisioning what that would be, how it would be presented in a way that is making it an aggravator.
Well, I would hope that it wouldn't be presented that way. But, Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And, of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him. And a lot of their unkind things, when you understand them in the context of autism, the way he may stand in a room near a doorway, the way he may look too long at a person, their interviews are different when you know he has autism and you know the characteristics he displays. But those awful comments, those mean comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I, though, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to in a mitigation aggravation penalty phase. Your position is that's due to his spectrum disorder, whereas the state's view may, no, that's not. That's his view of women and goes to motive, et cetera, and goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem, Your Honor. If the state, and
Do you want
I
me to,
wanna
you want
be
me to weigh in and
clear.
say what the factual findings are, that it's this and not that? And I'm not sure I can do that as short from a jury instruction that, you cannot use mental health conditions as an aggravating factor.
that's an appropriate jury instruction, and if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present mitigation.
There may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that the court will not find that that comes up. I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with and that Mr. Kohberger's constitutional rights are protected.
Thank you.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation. Thank you, Your Honor.
Response?
We understand that the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
Thank you. Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. The state certainly shouldn't make those arguments and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. So I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say don't make that argument that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the symptomology that the defense contends is part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor. All right. Why don't we take the morning break? We'll take 10 minutes and be back.
Well, guys, that's all that I have for the video footage. I think there's actually more, like probably, well, actually, I'm pretty sure there's more because I watched some of it, but I don't know if it was taken back up later if they actually finished or if they had to come back for a second day, like they had mentioned at the beginning. But I just wanted to share this with you guys because it's really so interesting. They're doing a lot of things that, this is kind of the stuff you see in movies, basically. It is a little bit slower. I mean, look how long it took just to go through this stuff, but they're putting out this information. They're trying things. They're trying to be creative. They want to present the best case for each side. And, we don't know if Kohberger is guilty. I mean, for me personally, it looks very bad. But hopefully when they find a jury, they will be fair and, they can get enough facts to make a great decision. But anyways, guys, I just want to thank you guys for being here tonight. Had a lot of fun hanging out. And if I can find more of this stuff, I'll definitely make some time to go over it again with the new stuff that comes out. I think this motion hearing is probably a lot more interesting. I know they mentioned a pretrial conference. That one probably won't be very interesting. It'll simply be, is everyone ready for trial? And then they say yes or no, why they aren't and stuff. So, but yeah, I think this is if you're interested in how court works, I think this will be the case that you probably want to use to get started into that. It's really just, it's going to be a good trial. But anyways, guys, I'll just go ahead and end it here. But thanks again. And as always, stay kind, be vigilant, and I'll catch you in the next video.